So I teach law here at QUT, and I can assure you that the last thing my students think of when they think of me or my classes on constitutional law is sex. Which begs the question then, why am I trying to make the pitch today that constitutional law is sexy? And the short answer is constitutional law is sexy because it matters. And it's more than just that. It's because it matters so much. It's because it is relevant to pretty much every major social, economic and political challenge that is facing our nation today. And because it informs and influences our very system of government. Indeed, in that respect, constitutional law isn't just sexy, it is like sex. We literally wouldn't be here without it. And yet, sadly, so many people, inexplicably, don't get turned on by constitutional law. Indeed, if you ask most people about the Constitution, they think of the movie The Castle and the vibe of it, which, by the way, was not a very good film. It simply doesn't create much excitement among the community. And sometimes law students are the absolute worst when it comes to this. Now, this example is a little extreme, and I'm happy to say that no student has yet become insane nor died as a result of one of my constitutional law exams, but it nonetheless reflects a general feeling of disinterest or ambivalence about the Constitution. And so what my pitch today is about is to explain to you, to prove to you why the Constitution matters so much. But before I can do that, I probably need to tell you a little bit about the Constitution. Basically, a constitution is a document that puts in place the rules for how any organisation is going to run, be it an association, a corporation, or a nation. And it sets up various institutions or individuals, gives powers to those individuals or institutions, and also limits those powers or institutions. Now, the Constitution of Australia came about in Federation in 1901, and it does 5 basic things. The first thing that it did was that it converted the various colonies we had in this country into states. The second thing that it did was to create a new level of government. Prior to Federation in 1901, we didn't have a federal or Commonwealth government. Instead, the various colonies were simply answerable to Great Britain. The third thing that it then had to do, and this is significant for us today, is divide power between this federal government and the various different state governments. The fourth thing that it did is important because it reflects what was really behind the push towards federation. And that is, it created a common market, or free trade between the states. And that was really one of the main motivators behind the Founding Fathers when they drafted the Constitution. And I can call them Founding Fathers without being sexist, because they all were middle-aged white men. And that was what their main motivation was. It wasn't about rights or freedoms, which is why the fifth thing that it does only in a very limited way, which is protect individual rights or freedoms. And indeed, the Constitution only contains 5 of these such freedoms, very few of which are going to particularly ignite much passion or enthusiasm. The first freedom that it has is the right not to have property acquired by the federal government on something other than just terms. Doesn't quite compete with notions of freedom of speech or double jeopardy. And indeed, that is the right that was at issue in the Castle, which, by the way, got the law completely wrong. The second right that we have is right to a trial by jury, which is contained in Section 80. And for technical reasons, just take my word for it, it's actually a pretty meaningless right because most criminal laws are state laws, not Commonwealth laws, so that provision is pretty much meaningless. Section 92 reflects that intention of the Founding Fathers to give us this free market, this common market between the states, and it provides for freedom of interstate trade, commerce, and intercourse, which perhaps is another argument as to why the Constitution is sexy. The fourth one is freedom of religion, and then the fifth one is the right not to be discriminated against on the basis of residency. That is to say, Queensland can't discriminate against residents of New South Wales and vice versa. the Constitution says nothing about discrimination on the basis of age, gender, sex, race, sexuality, whatever it may be. So what we can take away from all of this is the fact that our Constitution is a very practical, pragmatic document that is more concerned about separating power between the three branches of government and dividing power between the federal government and the state government than it is about protecting explicitly individual rights and freedoms. But that's not to say it doesn't influence those rights and freedoms and isn't very important today. It's just that it's a little more oblique, and so much is left up to the High Court of Australia, which is the body that is ultimately entrusted with applying and giving meaning to the Constitution. So what I'm going to do now is just briefly flick through a series of issues to show you how the Constitution affects some of the challenges that our nation presents today. The first one is marriage equality. The High Court at the end of last year had to decide whether same-sex marriage could be passed by the states and territories or whether it solely had to be a matter for the federal government. They ultimately decided it was a matter for the federal government, and so the ball is now firmly in its court because of that constitutional dimension. And it was fascinating when this case was playing out, because it was one of the few matters that actually seemed to generate quite a bit of enthusiasm and interest amongst my students when it came to teaching constitutional law. And some former students actually came up to me in coffee shops and places and wanted my opinion on the marriage equality case. And I like to think they wanted my opinion because they knew that I knew something about constitutional law, and it wasn't just because I'm a raging homosexual. There's also asylum seekers. So currently before the High Court today, or this at the moment, is the case involving those 157 Sri Lankan asylum seekers that the federal government was seeking to return to Sri Lanka. Again, it's a technical question as to whether the executive government could do this under its executive power or whether it was bound by the Migration Act. This seems technical, but its application actually goes to the heart of how we treat some of the most vulnerable people in our community. One group that's not so vulnerable then, obviously, are bikie gangs. But nonetheless, this raises important constitutional questions. In Queensland, we've had the state government give us the brilliantly named Vicious Lawless Association Establishment Act, nicknamed the VLAD Act, which imposes really quite draconian sanctions on bikie gang members and restricts their freedom of association, raising constitutional questions about whether we have any form of freedom of political association in this country, but also whether these laws infringe the separation of powers in the way in which they limit the discretion of the judiciary. Another pressing constitutional issue, and one area where our document is woefully inadequate, is in terms of reconciliation and recognition of Indigenous Australians. And this is actually, I think, a real weakness for our Constitution. And it's been sad to see a push come in the last 10 years to try and fix our Constitution in this respect by providing recognition for Indigenous Australians, as also removing various remaining discriminatory and racist provisions. But this push has yet to gain the full attention of the community or mainstream action, which is why we have seen a series of federal governments now put off having a referendum on this issue. Now, admittedly, having a referendum is a hard process to achieve. It's only happened 8 times in our Constitution's history where we've managed to amend it. But we need to see greater community engagement around this very important issue, and the symbolic recognition as well as substantive changes to the Constitution that can occur under this heading should demand our attention. Free speech. Now, I've already said that our Constitution doesn't protect free speech explicitly, but the High Court has found an implied freedom of political communication, which does recognise that there is some degree of speech that is necessary for political purposes. This influences the media, defamation law, electoral law, campaign finance, and the like. And while we're talking about electoral law, it may again surprise some people to know that the Constitution doesn't expressly protect or guarantee anyone's right to vote. Of course, when you think about when the Constitution was written, that makes sense, because in 1901, only land-owning white men were able to vote. But the High Court has, in recent years, in two important cases dealing with prisoners, as well as then changes to the time periods by which you're able to enrol prior to an election, found an implied right to vote. And it's hard to think of any concept or notion that is more important and fundamental to a vibrant democracy than the idea of the right to vote being found within our Constitution. The final two that I'll mention relate to government spending and also federation. And this is because, in many ways, our Constitution as a document is dysfunctional and fundamentally broken. And that's because the federal government raises most of the money through taxation, and yet it is the states that have to spend it, as they're the ones that provide most of the infrastructure, including things like education and health. The fact that our Constitution no longer meaningfully reflects the way in which the Commonwealth and the state governments operates should trouble us all. And it remains this issue of federation and fixing the so-called vertical fiscal imbalance that exists remains perhaps the most challenging question of governance that befalls our nation today. And we can only fix it effectively and meaningfully by engaging with the Constitution. So, what I'm trying to say to you all today is to take away from this the fact that the Constitution matters. And no matter what your particular area of interest is, be it marriage equality, asylum seekers, government funding for science, infrastructure, notions of citizenship and Aboriginal rights, no matter what your area of interest is, no matter what your passion is, the Constitution matters to it. So I'd encourage you to go away and to read the Constitution. Encourage others to read the Constitution and to talk about it. Now, I'm definitely not saying you should all become lawyers, because God knows we have enough lawyers. But what I am saying is that as citizens, we should care about this document and how it influences our life. So read it, have those conversations, and talk to people about how, if you vote, if you pay taxes, if you care about any of the political, social, or economic issues facing our nation today, the Constitution matters. And to be honest, I can't think of anything sexier than that. Although that might explain why I'm still single. Thank you.